that the 146 text messages between you and Mr. Fogel seems to be ends with your email that you gave Ms. Owens. I am alleging that he's committing fraud upon the court.
Written witness statement very much appears to not have been the full truth as revealed by Detective Kruger when confronted with cell phone records. Well, then I'm going to start to have concerns that your office is now a witness in this case. Ms. Owens, is the prosecution ready to proceed to a motions hearing?
The people would just ask that the court make a preliminary ruling as to that the defense does not set forth a legal basis for the motion. And we would just submit that without that legal basis, there's nothing for the court to rule on. Thank you.
I would say the court, if there has been fraud that is perpetrated upon the court in its inherent powers has a broad range of sanctions to whatever the court feels appropriate if fraud is shown to this court. And I will be able to establish this through the testimony of Detective Kruger. Not only fraud to the court, but actually possibly perjury during the trial of Ms. Sawyer.
I am going to proceed forward with the testimony today. Mr. Tellini, your first, I think this is your motions, your first witness.
Call Detective Kruger.
Detective Kruger, do you swear or affirm under penalty of perjury that the testimony you're about to provide this court will be the truth, the whole truth, and nothing but the truth?
Yes.
You can be seated.
How long have you been with the Fremont County Sheriffs?
That was just right about 10 years.
Okay. And during that time, you had some involvement in a homicide investigation regarding Ms. Gurule.
Yes, sir.
And then sometime last fall, you received an email from Ms. Owens
Yes.
regarding a discovery request I had made concerning Anthony Fogel acting as a confidential informant.
Yes.
And in that, you stated that he was a CI for a short time. Jeff and I...
Your Honor, I'm going to object to the leading nature of these questions. I allowed, the first few questions, just to establish things, but I'm going to object to the leading nature going forward.
Response, Mr. Tellini.
Yes, Your Honor, it's a motion hearing. The rules of evidence are relaxed. And on the other way, I would ask that the detective be treated as a hostile witness. I am alleging that he's committing fraud upon the court.
I am under Rule 611 going to allow the leading as an adversarial witness. He certainly is a witness, is identified as a critical witness for the prosecution at this point.
You responded that yes, he was a CI for a short time,
Yes, sir.
and that Jeff and I got him a deal and out of jail.
Yes, sir.
That Jeff would be Jeff Lindsay.
Yes, sir.
And that was in relation to that 21 CR 60 case in which he was charged as a special offender and looking at large habitual charges.
I don't remember exactly which case it was.
And in that case, Mr. Lindsay, who you worked on this with, gave Mr. Kruger a deal for careless driving.
I'm Mr. Kruger.
I'm sorry, Mr. Fogel.
I believe so.
Okay. And that was because he got out and he gave info on a large drug case.
Yes.
What drug case was that?
I don't remember the case number.
You remember who the defendant's name?
Yes.
Who?
Jason Baumgartner.
Okay. And that was a large case?
Large for us, yes.
Okay. And were you lead on that case?
Yes.
And was Mr. Lindsay the district attorney on that case?
No.
Okay. And that was the extent of it. I'm sure we texted a few times while he was out, and that's it.
Yes.
And then you follow that up with also none of that was during the time of the homicide. Not exactly sure of the dates.
Yes.
So you stated affirmatively to the district attorney that at no time relevant to the homicide was Mr. Fogel acting as a confidential informant for you.
Yes.
And then you went back and it turns out that there is a confidential informant file on Mr. Fogel.
I have to provide context. You're asking questions that are yes or no. I need to provide context and show what was going on.
Detective, after I'm done, Ms. Owens is going to be able to ask you questions.
Right.
You can provide all the context then. Mine are generally going to be yes or no questions and it'll go a little bit faster. Okay, and so that's what you would put in your email, that he was not a CI at any time relevant to the homicide.
That's true.
Okay. Was there a confidential informant file on Mr. Fogel for that time when he was a CI?
Yes.
And why has that not been provided in discovery? So why have you not turned that over?
So the best way I can explain it, if I may back up a little bit.
Sure.
To when he was in jail before we got him out. I have to show that he's credible. He has to give me a little bit of low-lying fruit. That way I can show my boss, the district attorney, that maybe we should get this guy out so we can use him on the streets.
Okay.
And that's what we did. We signed a CI agreement after he got on the streets. I totally forgot about it. My mistake. That's why we're here today. But when he signed the agreement, we did nothing. So it's almost like he signed up to play football, but he never came to practice, never came to the games. So was he a CI? No. Did he sign up to be? I wanted him to be. I was like, come help us, buddy. You're on the team. But he never was because he never did anything. Does that make sense?
I mean, part of the deal for him to get out on that careless driving from the mandatory 60-year prison sentence he was looking at, was he supposed to then cooperate with you after he got out?
He was signed up once he got out of jail.
It's your testimony here under oath that he was not acting as a confidential informant for you in December of 2021.
I don't remember the exact, listen, I wanted him to provide information. We spoke, we texted, we kept in communication. I tried to cultivate a confidential informant out of him. If he provided information, I was never able to corroborate it. If he told me about people, places, names, I was never able to corroborate it. Confidential informants are useful. He was useless. He said he was gonna, we talked, but he never provided anything. So to call him a confidential informant is false. I wanted him to be. Did he? No, he never provided anything credible.
Would you ever arrange for him with meetups with other individuals or the law enforcement agencies?
Yeah, him and I met on multiple occasions. And it was so superficial, and he pulled the wool over my eyes, and I wish I never would have got him out of jail.
You said in that report, checked my CI files, I signed up Anthony Fogel as a confidential informant on January 18th, 2022.
Okay, yes.
So 10 days later, you discovered that Fogel was a suspect in a gun theft case. So did you ever communicate to him that his role as a confidential informant was terminated on January 28th?
No.
So in his mind, he would have likely believed he was still acting as a confidential informant after January 28th.
Objection calls for speculation.
Okay.
I'm going to sustain that objection based on the question.
But you are admitting that you continue to seek information and contact him regarding crimes after you terminated his use as a confidential informant.
It's my job to talk to criminals.
And to be a confidential informant for you, what was he supposed to receive in consideration for that?
Nothing. He was already out of jail.
And is it your testimony that other than getting him out of the jail that you've never done anything for Mr. Fogel?
Never.
Okay. You, though, continued to have text messages with Mr. Fogel after January 28th through the homicide and after the homicide.
Yes.
And in fact, you had on February 7th, you had a 4-minute phone conversation with Mr. Fogel.
If that's what, yes.
Okay. And you were aware the indictment against Ms. Gurley charges the date of the offense as February 7th through February 8th.
Yes.
So you had a conversation with him, a 4-minute conversation on the phone, that includes the date that Ms. Gurley is charged with the homicide. But again, you indicated on your email initially that you'd had no contact with him after he got out of jail, and definitely no contact around the time of the homicide.
Okay.
And so that is not the same as what appears going on these text messages.
I mean, I understand what you're trying to do, and I get it.
Hold on. Let the witness finish the answer, and then I'll let you ask.
You're misrepresenting the thought process. And I understand, hold on. I understand that there's text messages and there's phone calls, but the reality and what's behind them is fruitless, is nothing. It's if he had given me a drug case during this time, if he would have provided credible information, if I would have been able to give him $100 to make a buy on the street, if I would have met him and we exchanged money to give him, if I would have put him up in a hotel room because he provided me some information, if there were any other cases that he was involved in as a CI under that CI number, you would know about it. There's nothing. So to say he's a CI, I would like to have had him be, but he wasn't. He was just a guy giving me information who I happened to get out of jail.
Okay.
Did we keep in contact? Yes, I keep in contact with lots of people. Tons.
You said before he gave me some info on a large drug case, that was the extent. I'm sure we texted a few times while he was out, but that's it. Then following up, also, none of that was during the time of the homicide. It was before. So that, would you agree with me? That indicates that you're saying you were not in communication with Mr. Fogel around the time of the homicide.
Everything you said is true. We texted a few times. That is what you're showing us texting a few times. Am I wrong?
I'm
You're trying to mince my words.
I'm not, these are your words. And you
Right.
said none of your communication with Mr. Fogel in an email that you knew was going to be response to the court. You said that you were not in texting with him. And I would put to you that the 146 text messages between you and Mr. Fogel during the time of homicide seems to be at ends with your email that you gave Ms. Owens.
Why wouldn't I stay in contact
Do
with
you
him?
remember testifying in the trial of Ms. Sawyer?
Yes.
Do you remember being asked if he was working as a confidential informant for you?
Yes.
And you remember kind of saying, well, that's what everybody says.
Yes.
Do you remember stating he introduced me one time to somebody who provided information to me?
Yes.
Your response was, then the question, okay. And then your response was, that's it.
Yes.
And so your response under oath was that the only information, only thing Mr. Fogel had ever done for you was introduce somebody to you at one point in time.
I feel like we're beating a dead horse. Yes, that is everything we
Okay.
talked about.
And that was your testimony under oath.
Yes.
Later on, about a week later, do you remember texting Mr. Fogel about wanting to meet some people? And I can,
Show me and I'll recollect my memory.
I'm looking to retext now.
3 down?
Yeah.
Okay.
Do you remember who that was supposed to meet?
We can meet this week. I come back tomorrow or Tuesday. I'll get at you first thing. Is that what you're talking
Yeah.
about? What was your question?
Do you remember who you and Mr. Fogel were supposed to meet?
We can meet. It says we can meet,
Okay.
so I assume him and I.
All right. Do you remember then following that up with a text, 20-minute tops, man. They want to hear what you have to say to see if you're interested. They are willing to pay. We can give you a ride back.
Yeah.
What was that in relation to?
DEA or FBI?
Okay, so the DEA was willing to pay Mr. Fogel?
I don't know. I don't know how to say it without feeding him a line. To see if he's willing to, just to see if what he has to offer is worth the time of a DEA agent or an FBI agent or an ATF. Because remember, we're talking dope and guns, and he talked that he could get a lot of dope and a lot of guns.
Okay, well, so I mean, but if you're meeting him up with DEA, you're saying that's still not acting as an informant for you?
We never met with the DEA, so no.
Okay.
We talked about it. Yeah, I tried to, but no. So
You
no.
remember also, then later texting, it's on you, man. You got to want to hear these dudes out. They got pulled with parole. Just being a man of my word.
Yeah, that's me trying to put in his ear that, hey, man, if you want to get big guns and big dope, maybe I could get the DEA involved and we could do something. And federal snitches make a lot of money. They get hotels, they get cars. I mean, it's the real deal. Yes, we had conversations. We talked about a lot of things. We talked about drugs and guns and people and places and different states and all kinds of things, but nothing ever happened. What am I to document?
Do you remember texting him, if you can get me in a position to get Nutso mobile with weight and strap, they got 500 for you?
No, but I remember talking about Nutso. I think it's right here somewhere.
Let me approach.
Yes.
I'm asking, did you relate to him, help you get Nutso, you get 500 for him?
Yeah.
Who was that 500 coming from?
Probably me from Buy Money.
Okay, let me approach.
Yes.
Do you remember then Mr. Fogel responding to you? You guys mentioned Nutso. I need cash to fuck with him. That's the only way to get him where we need.
Sure.
Okay. And you remember responding right on, Nutso may have to wait till after parole. It's a year soon. Where should I be back looking to snap some weight?
Okay.
You then ask, what were your pics of? The next text message.
Okay.
So he was sending you photos of suspected drug dealers.
He could have been. I'm sure you have them. Let's see them.
Well, I mean, he then texts you, those pictures were a conversation I was having with Rob Roberts. It's the guys you were looking for.
I don't remember. I mean, we're going to go through.
Fine.
I may approach?
Yes.
Okay, we're going to the home
Okay. Which one specifically? What are we,
where you say over those pictures up and he responds. Those were a conversation
what were your picks?
with Rob Roberts.
The pictures were conversations that Rob Roberts, the guy you all were looking for. Okay.
Okay, so he had sent you pictures relating to a drug conversation with Rob.
That was 99.9% sure. I'm going to say I was unable to cooperate.
Okay, but he did give you photos of a conversation.
I don't remember. It says he did, so I'm sure he did.
Okay. And so that would contradict your statement under oath that all he had ever done for you was introduce you to one person and never done anything else.
What are you're mincing words? You're painting a picture that is untrue and inaccurate.
And so
I'm just,
she'll be able to clear that up for you.
okay.
Do you remember then in January 11th of 2022, asking, do you still have the pics of that conversation with Robert Robb? I would like to see them.
No.
Well, looking at that refresher reference.
Yes.
You texted him that you still want to look at the photos that he was providing.
Yes.
And you want him to email them to you?
Yeah, that's what it says.
And then he does.
Okay.
You respond with several questions afterwards, asking if one of the photos was Cordero Mars.
I don't remember. I'd have to might as well bring it up.
All right.
Might as well bring the whole binder so I could just look at it one at a time as we go over it.
He sent you pictures and you were asking him to identify people in those pictures.
That's what it says, yes.
On January 16th, you texted him, can you throw me a bone or something good in town? You follow that up with, I hear there's a bunch of black and clear coming in somewhere and I want it.
I don't know. I don't remember.
That reflects your recollection.
Yes.
And so you told him, I hear there's a bunch of black and clear in town, I want it.
That's a yes. I mean, I can
Okay.
provide context, but yes, that's what,
Well, it's your text message.
yeah.
Darcy is married to my brother's wife. Also ask your boss about Darcy. He knows her, busted her once before.
I mean, I don't remember, but if that's what I said, that's what it says.
So he said, check with your boss. He's busted her once before.
Okay.
Did you ever check with your boss?
I don't remember.
Do you remember communicating with Mr. Fogel around January 26th?
No.
There was a text message where he's offering to set a pit and the time to do it is right now. Would you like to see it? So he texts you, the time for pit is now, and you do not get back from him for 3 days because you were sick.
That's what it says.
At no point ever again do you text him that he's no longer a confidential informant.
I don't remember.
Okay. And then on February 11th, you text him, what's the word on the street with the Phantom Canyon shit?
Okay.
And so you are asking if he has information about the homicide in question.
Okay.
And then again, you eventually go and have the meeting with him and the FBI.
Okay.
Do you remember responding to her, you know, all I've done for that man, I've done more than anything, including sacrificing my reputation.
That's been brought up. Yes, I remember that.
Would you like to listen to that?
I remember it.
So you remember telling her that you have done, that Brandy was aware of how much you have done for Mr. Fogel.
Yeah, I got him out of jail.
Okay.
What do you mean? Okay?
And then why was doing that sacrificing your reputation?
Because he was a really bad guy who a lot of people thought didn't deserve to be out of jail.
And that, not all the other phone conversations with you, not the fact that he killed two people. It has nothing to do with that.
What are you trying to say?
When you say your reputation, who did you lose your reputation to?
Well, nobody.
Well, you said it.
You have to, you're,
Hold on. Let's make sure we are not interrupting each other.
is it me or him talking right now?
I'm going to, Mr. Tellini, restate your question so that there's clear, we're not interrupting each other.
You told Brandy Fogel, Anthony Fogel has cost you your reputation.
Are you saying that or asking that?
I'm stating, well, you've admitted you made that statement. I am asking, in whose eyes did you lose your reputation?
You understand that during a homicide investigation, any investigation, that sometimes you say things to elicit certain responses out of people. That's kind of a tactic or an investigative technique. A lot of people use it in interviews, interrogations, whatever you want to call it, or maybe even talking to the suspect's old lady or wife. Sometimes you say things, I don't know why I said it, and I don't think it necessarily matters. You're painting the picture like I'm a certain type of cop, and I understand why you're doing it. But the fact is, why I said that at the time, I can't tell you exactly why. All I can tell you is that probably it's because I got him out of jail. I got him off of a dope and gun case to get him out of jail. It's not because we were helping each other and doing all these crazy things and doing shady things behind the scenes during a homicide, after the homicide, or before the homicide. So to infer that is 0% true.
Okay, and again, when you said you lost your reputation, in whose eyes had you lost it?
Nobody.
Okay, so that was just a fabricated line to Ms. Fogel?
It's me interviewing a suspect's wife or girlfriend, whatever she was.
I'm just asking your words. When you said Anthony has cost you your reputation, you're just saying that was just a technique and had nothing to do with actuality.
I don't remember.
Well, again, when listening to that, refresh your record.
No, it wouldn't. I
I
remember
don't want anybody to hear that, do you?
play it.
But I can't. I need
You turn it up a little bit. I can't hear.
No, I don't want to just like.
We'll work on that.
You know how hard this is for me to.
That's why I wanted to come down here and talk to you face to face. That's why. You don't think you know I've done my fair share for that man.
I know that.
You know that?
100%
And
know
for
that.
and for him to
That shit cost me $50,000 last year with all that shit.
cost me a reputation.
When you say it cost your reputation, who'd it cost?
I mean, that is exactly what you said. I said, and I don't want to, I can't speculate on what I meant at the time. To me, that's so insignificant.
So pretty good. With the reputation, are you referring to that yourself and Mr. Lindsay got a guy out of jail who then went on to commit a double homicide?
Your Honor, I'm going to object. The witness has already testified that he doesn't recall.
Overrule that.
I don't remember at the time, honestly.
And is the damage to your and Mr. Lindsay's reputation for getting Mr. Fogel out of jail, for him to kill two people, is that why he's basically been giving a time served offer in this case?
If there was
That, do you know if that's the
I'm
case?
trying to answer.
Your Honor,
Hold on, finish your question. Don't add to it after, Mr. Tellini. Let's make sure that we are answering after the question is over.
Is the loss of reputation for you and Mr. Lindsay in getting Mr. Fogel out of prison on a case he was looking at the rest of his life, and then he goes and commits a double homicide, are you aware if that's why he was given the deal that he has in this case to save both face for you and Mr. Lindsay?
objection calls for speculation.
I'm asking if he's aware of.
I'm going to overrule the objection.
I have no loss of reputation. If I did, I wouldn't be sitting here right now. I haven't been written up. I haven't been reprimanded. I haven't been asked any questions by the DA previous to him or the current DA. I have
More
no
questions.
Cross-examination, Ms. Owens.
Thank you, Your Honor. And would it be fair to say that when you were trying to work on Mr. Fogel being a confidential informant in early, the end of 2021, early 2022, that he just never provided you with anything that you would have considered tangible and useful information?
Had he provided me any information on anything, there would be arrests, court documentation, there would be cases supporting all the things that he provided me information on. Anything, but there's nothing.
Nothing?
There's nothing.
Nothing in his CI file?
Nothing anywhere.
Nothing anywhere?
Nothing.
All right. I don't think I have any further questions. Thank you.
Redirect?
There you go.
All right. Secretary Kruger, you can step down. Thank you.
Thank you.
All right, here's what I would like to do. I'm going to allow the parties to do simultaneous briefing and then have the parties back. I was looking at 8:15 on June 11th.
This is one of the strangest things that I've seen as far as Detective Kruger and Anthony Fogel and the continued obstruction and hiding by the district attorney's office and Detective Kruger regarding the relationship between Detective Kruger and Mr. Fogel. 147 phone calls and text messages, and that's just only at the time of the homicide, because that's the only information we have from Mr. Fogel's phone, because of the limitations of the coke on the search warrant was only for that time frame. And then to have him get up there and continually try to deny that Anthony Fogel was acting as a CI for him during this time frame flies in the face of reason and common sense. We have him then actually signed up via CI January 18th of 2022. a couple of weeks before the homicide occurs. Again, this is in direct contradicts the prior email in response to my discovery issue. The rationale behind it, or that Detective Kruger gives, is absurd. He said under oath that the Anthony Fogel was not getting anything for signing up to be a confidential informant of January 18th of 2022. And his exact words were, he was doing me a solid. There's no documentation he was ever terminated as a CI. And in fact, he is calling him up saying, what do you hear about, what's the word on the street about the Phantom Canyon homicides? And then Mr. Fogel, after a 20-minute phone conversation that Detective Kruger cannot remember the context of, talks to him for 20 minutes, then they go and meet with him and the FBI. That is impeachment information. That is Brady. That is Gigolo. I fail to understand that. And them acting like we don't know what's going on is directly disputed by the fact of the person who did this deal with Mr. Fogel to make him a CI is Jeff Lindsay. And I would put it to the court, what reason and common sense says is they did a deal with Mr. Fogel and he was supposed to then get out and be a confidential informant for them. They circumvented DOC's policy of not having parolees act as informants. And that's why there's no other documentation in there. We had Detective Kruger admit he knew he couldn't have Mr. Fogel make buys, do rips for him until he was off parole. But clearly that obligation for him to do all this was directly related to the case that Jeff Lindsay dealt. And we have that same district attorney who made that deal is in the one signing off for Anthony Fogel, getting a deal that's basically amounts to time served for murder. And it's important to note in the grand jury transcript, it was presented to the grand jury by their office that Mr. Fogel was the one that shot Mr. Ryan. I don't want to sound dramatic, but this feels a lot like a Whitey Bulger situation. We've got somebody who is actually working as a confidential informant and then commits a murder, and they're trying to cover it up because I don't think Mr. Lindsay wants it out there that he released a dangerous felon and that felon murdered somebody. I will remind the district attorney, it's anything that would be helpful to the accused, anything that could be impeachment. The case law is, abundantly clear that impeachment information needs to be discovered. Their star witness was an active CI for this the entire time, and they are still hiding them. And that in response to this relationship that we have Detective Kruger, I'm just going to perjure himself over and over again on that stand. In their response, they don't even try to deny that he's perjuring himself. They're just trying to say the court can't do anything about an officer of the law coming in here and lying, that the court's powerless to do this. They don't even try to dispute the absurdity of what that guy testified to. It is a discovery violation. It is a Gigolo violation. I think he should actually be brought up on attempt to influence a public servant. I've seen people charged for far less than what he has done in this matter. That's all I have, Your Honor.
Thank you, Mr. Tellini. Ms. Owens or Mr. Tommy?
Thank you, Your Honor.
Before you get started, can I ask, the court heard testimony during the hearing that Detective Kruger had a confidential informant contract signed or documentation of that. Has that been disclosed in discovery?
Yes, it was discovered back in February when we received it from Detective Kruger.
But what has not been disclosed is the agreement that he made back in February of 2021 with Jeff Lindsay and what his requirements were under that agreement. That has not been disclosed.
Ms. Owens, I do have some issue with the fact that this case has been pending since 2024 and that wasn't disclosed until a month before our original trial setting.
Honestly, nobody had asked for it until Mr. Tellini asked for it.
And you think that changes your obligation under Rule 16?
Your Honor, it would be discretionary discovery.
Brady is...
Hold on.
Okay, sorry.
I'll give you the chance, Mr. Tellini. I'm inquiring questions of Ms.
I apologize for that.
I guess I have some concern, even if ultimately the prosecution was operating under a theory that this was discretionary discovery. Once the prosecution made an offer to Mr. Fogel and attempted to complete that offer in January and was still intending to have that offer be accepted by the court, why that wasn't provided sooner. And I agree. I think that's very much exculpatory information for either of the other co-defendants. But go ahead, I'll let you make your argument, Ms. Owens. That is concerning to me, though, that the response is, well, it wasn't asked for.
And then otherwise, with regard to the motion, we would stand on our written brief that the credibility of Mr. Kruger, or Detective Kruger's testimony is a matter for the jury. The court can't use its inherent authority to invade the province of the jury, and that otherwise the court should deny the motion. Thank you.
Response, Mr. Tellini.
Brady material is neither discretionary under the rule, under the United States Constitution, the Colorado Constitution, and specifically under the rules of professional conduct. This idea that they don't have to disclose impeachment information, such as their prime witness was a confidential informant during the time this goes on, that unless somebody specifically asked for it, is ludicrous. This, like, that they continue to perpetrate this idea that he was just let out on a careless driving and was just communicating with Detective Kruger for this entire year period, giving information on drug dealers, telling when they were coming in, out of the kindness of his heart and not an obligation to the deal made in that case, again finds in the face of reason and common sense. I think the court can look at reason and common sense by what is going on here and find that they are still hiding it. And it's not anything that even be that difficult. Jeff Lindsay is the district attorney, is in an office with them. Again, I think flies in face of their obligations under Rule 16, Brady, and the rules of professional conduct. The Colorado Supreme Court found there has been an ongoing pattern of discovery violations by this district attorney's office, that they do not seem to comprehend Rule 16 or discovery, Brady, what material needs to be disclosed. So under Tippett, the court has broad authority to do this. The court has broad authority to discourage law enforcement from coming and lying to the court in a double homicide case. Kind of crazy stuff, but Kruger's saying, no big deal, move along, nothing to see here. Casts a lot of issues on this district attorney's office for how they are handling this case. Again, in the preferential treatment that Mr. Fogel seemed to get time and time again from this office, and we still don't understand why. And they have the person in their office who can answer these questions, but they are hiding stuff, and I would say they're hiding stuff on his behalf.
Your Honor, if I could just briefly respond.
On a limited basis, I'll allow it.
Your Honor, it sounds like what the defense is really asking for is work product, and it's black letter law that work product is not discoverable.
Well, hold on real quick, Ms. Owens, because I'm going to take offense to that myself from the court. When your witness testified to the fact, and I think even wrote a witness statement that Jeff and I got him a deal and out of jail, and that plea agreement doesn't detail that information. We're going beyond work product at this point to exculpatory information.
If we're going to be talking about work product, and I'm actually looking at the work product notes that are in the case, and I'll be honest.
What I'm indicating, Ms. Owens, the plea agreement that was signed before the court, the plea agreement that was accepted with the court, does not include any information about cooperation or providing information to law enforcement. So how else is this information going to be disclosed when your own witness testified to the fact that that was part of the agreement for him to be getting out of custody?
And Your Honor, I'm looking at 21 CR 60, and there are no notes documenting the negotiations that got there.
That's my point, Ms. Owens, and that's the problem. That is the problem. You're not seeing the problem here, is that your witness testified to the fact that he worked with Mr. Lindsay, your office, to give this deal, a very favorable deal based on the original charges, and that there is no documentation within your office whatsoever, and that documentation that is there is work product?
As I said, Your Honor, I do not see any documentation in the file specifically memorializing how the agreement came to be. I can't discover something that's not in the file.
Well, then I'm going to start to have concerns that your office is now a witness in this case, Ms. Owens. And to say that there's no documentation of why this individual received the sentence he did in that case. Certainly, I think without that information provided to the court, I know I wouldn't have accepted a plea agreement like that. But go ahead, I'll let you finish responding to Mr. Tellini.
That was my response, Your Honor. We can't discover something that we don't have documentation of.
It is concerning to me, very concerning to me, to have a written witness statement provided to the district attorney's office from a detective at the sheriff's office indicating and I'm sorry, some of these words are terms of art to say he ghosted me once he got out of jail, yet in January, there's a signed confidential informant agreement 1 month or less than the date of offense in the homicides in this case, to indicate that none of it was during the time of the homicide, and yet there's phone records to indicate that it wasn't just we texted a few times. Phone calls would be very much the direct opposite of text messages. A phone call on the night in which the homicide occurred, a phone call before going into potentially providing information to law enforcement about the homicide in question. The court heard testimony regarding that both at the Sawyer trial and during Detective Kruger's testimony for the hearing in this case. It is concerning to me, Ms. Owens, the fact that this is not being treated as a potential. This is extremely concerning to me, and I've seen it internal affairs investigations as to officer truthfulness for much less. And to think that this is being brushed over is concerning to me. I am not finding, based on the authority provided by the defense, that the court has the ability right now to suppress Detective Kruger's testimony. I guess what I would ultimately say, though, is that his credibility is in question based on the testimony he provided and the witness statement he effectively provided to the district attorney's office, I believe in December or early January of this year, specifically stating, let me know what you need. If anything, I've never dealt with anything like this. In a nutshell, yes, he was a CI for a short time. Jeff and I got him a deal to get out of jail. Once he got out of jail, he ghosted me. Before he got out, he gave me info on a large drug/gun case. That was the extent. I'm sure we texted a few times while he was out, but that's it. Also, none of that was during the time of the homicide. It was before, not exactly sure what dates. And what's concerning to the court is that written witness statement very much appears to not have been the full truth, as revealed by later testimony of Detective Kruger when confronted with cell phone records. That's concerning to the court. The district attorney's office now has obligations under Brady regarding Detective Kruger's testimony in potential other cases. Is what is before the court is an act of dishonesty, or what appears to be an act of dishonesty, and it's concerning to me. And obviously this court is not unfamiliar with this detective and testifying on multiple different cases in front of this court. And that leaves the court to determine what sanction is appropriate here. And the sanction I'm finding is appropriate is that there will be documentation provided to the court from Mr. Lindsay pertaining to the exact expectations of the plea agreement in 21 CR 60. I am finding, and it should be explicitly clear, that a witness or a co-defendant who is acting as a confidential informant at the time of the date of offense, or at the very least, very much close in time, within a month, signed the paperwork to act as a confidential informant, would be exculpatory information or information that is in your possession or control, which would tend to negate the guilt of the accused. And it is within your control if it is in possession of law enforcement, and the case law supports that. So I guess I want to make it clear, it is not discretionary. It should never be considered discretionary. The court shouldn't have to educate the district attorney's office on exculpatory information and their obligations to disclose. Ms. Owens, what is your position on that being a discovery violation in and of itself, for having it not, those items not been disclosed until yesterday on one of them, and the rest of it still has not been disclosed?
Well, with regard to the jail video, the jail calls, that is from a separate case. With regard to the other two matters, we do not dispute that those were not disclosed in a timely manner.
Go ahead, Mr. Tellini.
And again, part of the issue in this case is where this information is found. The information from Detective Kruger about Mr. Fogel making phone calls from the jail to murder witnesses was basically kind of like in a footnote on a report, how anybody could argue that their star witness making phone calls from the jail to have witnesses killed, whether it's on his case and other, I don't know what cases because that hasn't been discovered, but how that could not be incredibly apparent to the district attorney's office that would be exculpatory, again, is beyond me and flies in the face of Brady. Suzette Sawyer went to trial with a hung jury when this information was withheld from her. The harm that is being done by, again, this district attorney's office, flippant regards for the rules of discovery and due process is very, very concerning.
Ms. Owens, I'm going to order for those jail phone calls to be disclosed or filed with the court. I think I'd like to review those before I consider what sanction here. I think it's clear to the court that there is a discovery violation, multiple discovery violations. The fact that the confidential informant agreement wasn't provided until January. The fact that there's 2 recorded witness interviews that still haven't been provided. This case has been pending for over 2 years. And just then the prosecution decided to comply with their obligations under Rule 16 regarding disclosure of information that might tend to negate the guilt of the defendant. I want to make it clear that the prosecution is to file those phone calls to the court, and within 14 days, there is to be an affidavit filed with the court as it pertains to Mr. Lindsay's knowledge of the plea agreement extended in 21 CR 60, since your office is claiming you have no record of the agreement or why the agreement was extended in 21 CR 60.
I just let the court know, based upon what was stated here today, I anticipate filing, endorsing Mr. Lindsay as a witness, and I'm also going to file a motion for a special prosecutor.
I'll see the parties then for our pretrial readiness conference, a hearing, and the court's oral rulings on July 9th at 2:00.